2017 CR 1505, State of Texas versus Otis McKane. Present in the courtroom are all four attorneys for the state, the three attorneys for the defense, as well as the defendant. The court has provided to the parties the official final charge of the court, other than the objections already lodged. Are there any additional objections, suggestions, or remarks as it relates to the charge of the court?
None from the defense.
None from the state.
All right, let's bring him in.
All rise for the jury. You may be seated.
All right, welcome back, members of the jury. As I indicated to you before the break, you've heard all the evidence that you're going to hear during this portion. This is the first phase of this jury trial. However, you've not yet heard the law. I have before you a document that is entitled Charge of the Court. I'm going to read this document to you in its entirety. It basically contains all the law that you need when you continue to deliberate this particular case. As I indicated before, I'm the judge of the law in this case. This is a law that I prepared for you. Once I'm done advising you as to what this law is, each side will have an opportunity to then present closing arguments to you. Subsequent to that, this original document will go back with you and will be used by you during your deliberations. All right, charge of the court. Members of the jury, the defendant, Otis McKane, stands charged by indictment with the offense of capital murder, alleged to have been committed on or about the 20th day of November 2016 in Bexar County, Texas. The defendant has pleaded not guilty. Number one, our law provides that a person commits the offense of murder if he intentionally or knowingly causes the death of an individual. A person commits the offense of capital murder when such person murders a peace officer who is acting in the lawful discharge of an official duty and who the person knows is a police officer. Individual means a human being who is alive. Peace officer means a police officer of an incorporated city or town. A deadly weapon means a firearm, or anything that in its use of intent or intended use is capable of causing death or serious bodily injury. Firearm means any device designed, made, or adapted to expel a projectile through a barrel by using the energy generated by an explosion or burning substance, or any device that is readily convertible to that use. Number three, a person acts intentionally or with intent with respect to a result of his conduct when it is his conscious objective or desire to cause the result. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause a result. A person acts knowingly or with knowledge with respect to circumstances surrounding his conduct when he is aware that the circumstances exist. Number four, now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 20th day of November 2016, in Bexar County, Texas, a defendant, Otis McKane, that he did intentionally or knowingly cause the death of an individual, namely Benjamin Marconi, by shooting Benjamin Marconi with a deadly weapon, namely a firearm, and Benjamin Marconi was a peace officer acting in the lawful discharge of an official duty, and Otis Tyrone McKane knew Benjamin Marconi was a peace officer, then you will find the defendant guilty of the offense of capital murder as charged in the indictment, and do not consider paragraph 5. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, or if you are unable to agree, you will next consider whether the defendant is guilty of the lesser included offense of murder as instructed in paragraph 5. Number 5. If you unanimously find from the evidence beyond a reasonable doubt that on or about the 20th day of November 2016, in Bexar County, Texas, a defendant, Otis Tyrone McKane, that he did intentionally or knowingly cause the death of an individual, namely Benjamin Marconi, by shooting Benjamin Marconi with a deadly weapon, namely a firearm, then you will find the defendant guilty of the lesser included offense of murder. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty. Number 6. You are instructed that unless you believe from the evidence beyond a reasonable doubt that any statement made by the defendant that was introduced into evidence was freely and voluntarily made by the defendant without compulsion or persuasion, or if you have a reasonable doubt thereof, you shall not consider such statement for any purpose nor any evidence obtained as a result thereof. Number 7. You are instructed that if there is any evidence before you in this case regarding the defendants having committed acts of misconduct other than the offense alleged against him in the indictment in this case, you cannot consider said evidence for any purpose unless you find and believe beyond a reasonable doubt that the defendant committed such acts of misconduct, if any were committed, and even then you may only consider the same in determining the motive, opportunity, intent, plan, knowledge, and or identity, if any, of the defendant in this case, and for no other purpose. Number 8. Our law provides a defendant may testify in his own behalf if he elects to do so. This, however, is a right accorded a defendant, and in the event he elects not to testify, that fact cannot be taken as a circumstance against him. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations, or take it into consideration for any purpose whatsoever as a circumstance against him. Number 9. Written statements made by a witness to investigators or other officers or police reports made by officers and tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Oftentimes, statements and reports may be marked with an exhibit number but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case. You may not use any electronic device or media, such as telephone, cell phone, smartphone, or computer, the internet, any internet service, or any text or instant messaging service, or any internet chat room, blog, or website to communicate with anyone any information about this case, or to conduct any research about this case until I accept your verdict. The grand jury indictment is not evidence of guilt. It is a means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in passing upon whether the defendant is guilty or not guilty. Now, during your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case which is not shown by the evidence. You are instructed that you are not to let bias, prejudice, or sympathy play any part in reaching a verdict in this case. The burden of proof in all criminal cases rests upon the state throughout the trial, and it never shifts to the defendant. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has a burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt after considering all the evidence before you and these instructions, you will acquit him and say by your verdict, not guilty. You are the exclusive judges of the facts proved, of the credibility of the witnesses and the weight to be given the testimony, but the law of the case you must receive from the court as contained in these instructions and be governed thereby. You must disregard any comment or statement made by the court during the trial or in these instructions which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication was intended. After argument at counsel, you will retire to the jury room, select your own foreperson, and proceed with your deliberations. After you've reached a unanimous verdict, the foreperson will certify thereto by filling in the appropriate form attached to this charge and signing his or her name as foreperson. The form is not intended to suggest to you what your verdict should be. Now, your only duty at this time is to determine whether the defendant is guilty under the indictment in this cause, and restrict your deliberations to the issue of whether the defendant is guilty or not guilty, and nothing else. If the jury wishes to communicate with the court, they shall advise the bailiff. Any communication related to the case must be written, prepared by the foreperson, and shall be submitted to the court through the bailiff. Respectfully submitted, Judge Ron Rangel, 379th Judicial District, Bexar County, Texas. And on the back is the verdict form for you to use. All right, State, are you ready for closing argument?
We are, Your Honor.
You may proceed.
Please, the court, counsel. The only thing that would soothe my soul at that moment was to beat somebody up or to shoot somebody. You all heard that with your own ears, and you saw it with your own eyes, and it's readily apparent he wasn't forced to say anything. As a matter of fact, he thought he was sharper than Detective Duke. He wanted to find out what Duke knew. That's the type of man he is. Now, to shoot somebody, we all know who he shot. This isn't a whodunit. We know it was him. And we know who he shot. The story of Ben Marconi, which began on the day he was born, is yet to be finished. I suggest you people are going to write a chapter in that story. It's yet to be written. But what we need to know, and what is beyond all dispute, is that this is the handiwork of Otis Tyrone McKane. And you can look at this, and on the one hand, you almost want to apologize because that's sick to look at. It must be sick for his family to look at. I hope we haven't all gotten so inured to violence on TV and in the movies that we can't look at that and not be moved. That's a human being. Someone he didn't even know. Remember, he said it could be a 21-year-old rookie. He had no idea about Ben Marconi. And by the way, this texting thing, you think there's any evidence he knew that Ben Marconi was texting before he pulled over? And you saw the traffic stop. You all saw it. It was a legitimate traffic stop. And we all saw what happened. You think he knew Ben Marconi was texting? No. Talk about grasping for straws. But this shows beyond all dispute that he was acting in the performance of his lawful duties. He wasn't aware it was coming. Everybody told you that. Everybody said what a cowardly act it was. It was an execution. This coward has to sneak up on somebody from behind and put the barrel of a gun directly on his head. You heard Dr. Rouland say that. Do you think there's any question that he acted intentionally and knowingly? There is none. Do you think there's any question he knew Benjamin Marconi was on a traffic stop? There is none. You can see him going around the place. I think Miss Patterson, Jennifer Patterson, described it the best. It was like prey. It's almost like a predator going to the watering hole. He'd been there in the morning, and by God, 3 hours later, he's going back. And you know what was on his mind? It was still on his mind. It hadn't left his mind. He acted like a predator. And you watch those videos, and that's who he is. Who else says something like that? The only thing to soothe my soul? To give you a piece of calm? That's sick. That's what a predator would say. And he didn't know this man. But this tells you everything you need to know. It tells you it happened in Bexar County. It tells you it was a police officer in uniform. Everybody told you his lights were on. It was a traffic stop. He was acting in the lawful performance of his duties. Do you see a cell phone in his hand? You see a cell phone in his hand getting a text message when he puts a gun to the back of his head? No, because that's a ridiculous argument. We all text throughout the course of the day. Do you think a surgeon, he or she's not performing up to the medical code because maybe they get a call from a kid or their loved one or something? Do you think police officers are any different? Do you think they're allowed to get personal calls while they're at work? I think so. You heard Detective Duke said that's not prohibited, and they didn't prove otherwise. They didn't bring anything otherwise.
Checking on and shifting the burden to the defense. The defense never has a burden.
Overruled.
Zero evidence on that was prohibited. This act of his conscious desire, it was evil,
We're going to object, Your Honor.
Ego-driven.
The prosecutor continuously approaching the defendant, Your Honor. He can make his argument in front of the jury, Your Honor.
And I'm observing the state make the argument. I'll overrule that objection.
it was evil, and you know that from what you saw. It was ego-driven, and it was execrable. And when he says, and I'm not even going to get into all the things he said, because Ms. Strauch can get into that, but he meant to fuck somebody's life up. Somebody's. Didn't matter. Well, do you think he fucked up the life of Ben Marconi and Ben Marconi's family? You think he fucked it up well enough? You think he did a good job? He seems to be proud of it because it was the only thing that was going to soothe his soul.
Your Honor, to a comment on the defendant's right to remain silent.
It's in the video, Your Honor.
That he's proud of it. Your Honor, it's a comment on the defendant's
It's a
right to
reasonable
remain
inference
silent.
from the evidence when he says it will soothe his soul, Judge.
I'm going to overrule, and I'm going to again instruct the jury that the defense does not have a burden in this case whatsoever. The entire burden is fully on the state. Right, you may continue.
Thank you, Your Honor. He wants to make them feel the burn. He wanted to make the San Antonio Police Department feel the burn. You think he did? I think he did. You all heard about this massive manhunt for this guy and his car, and who was walking into the lobby at 7:30 in the morning, and then who comes back in the same car at 11:38, 11:34 that afternoon. Now, there's a thing in your charge about his Miranda warnings or his statutory warnings, because you can consider if his statement was not voluntary, then you don't have to consider it. Well, I want you to remember Detective Duke. I don't think anybody will accuse him of being a fast talker. The man's one of the slowest talkers I've ever seen. But he's very thorough, and he's very patient. And you saw how he read the warnings to Otis McKane. And so let's just go over them. You have the right to remain silent. You don't have to make any statement at all. But any statement that you do make may be used against you in a court of law. You have the right to have a lawyer present now, prior to questioning or during questioning. If you're unable to hire a lawyer, the state will appoint one for you. To advise you now prior to questioning or during questioning, and you have the right to terminate the questioning at any time. And he said, do you understand these rights? And Otis McKane said, yes. He knew that all the foregoing rights he had. As a matter of fact, not only did Chief Mackay come in and say, hey, I'm here to hear any complaints. Did he read you your rights? Yes. Did you understand your rights? Yes. And that's important because remember when he first gets into the interview room with Detective Duke and he says, they didn't tell me nothing. And he's talking about Enfinger and Moscoto, the two SWAT officers who brought him from the scene of the arrest to the San Antonio Police Department. They didn't tell me nothing. And of course we know that because they said, we didn't talk to him. We didn't read him his rights because we weren't asking him any questions. And he says, they didn't even read me my rights. So he was very aware of his rights. And he voluntarily, knowingly, and intelligently gave them up and then told you what is all too apparent. After lying initially 5 times about even being down at the station, and then lying a total of 19 times before he ultimately admits to what he did. And of course, all that was after he was trying to find out from Detective Duke, hey, how much do you know? He was trying to see, is there any room, can I get out of this? Can I get out of this? And Duke says, you mean, is there any room for negotiation? No. Why don't you tell us where the gun is? Well, will that help me? Will that help me? No, but I can tell the family and maybe some kid isn't going to find this gun out in a field. He says that the SWAT officers were rude to him. Remember, this man was speaking his mind to Detective Duke. They were rude to me. I guess the SWAT officers who just had a brother officer killed within 24 hours by being shot twice in the head, a public execution in front of public safety headquarters on a beautiful Sunday morning in San Antonio, Texas, Bexar County. Wow, they were rude to him. They weren't anything more because he would have said. They asked him, do you have any injuries? And remember the only injury he complained of at the end? I got a Charlie horse. Got a Charlie horse. And they took photographs of his body. There weren't any injuries on his body. But they were rude to him. He's mad because they were rude to a man who shot one of their brother officers 2 times at point blank range in the head. That's shocking. And the other thing is, if he wants to make any complaints about Enfinger, remember when you watch the video, Chris Enfinger, the SWAT officer who brought him in, was in and out of that room. And he could have said, Detective Duke said, well, do you recognize any of the guys who were rude to you or manhandled you at the scene? Well, no. And Enfinger is in and out of that room. If it had been Enfinger, if he put a finger on him, you would have known about it. And remember what Frank Rodriguez, who's now a detective, said. When you're on the SWAT team, the number one thing they teach us is you got to control your emotions. Because I'm sure they probably didn't care for this guy or what he did. Is that a shock? He said, but if we let go of our emotions, we endanger ourselves, we endanger our teammates, we endanger the public. So we keep our emotions in check and we do the mission. So this is one thing I want to talk about because I anticipate they're going to say, well, some of these things that Enfinger and Parker Morris, who was a detention officer at the time at the magistrate's office, talked about what Otis McKane said to them. And we know Otis McKane on the video that you all saw says, and this isn't the full list, but says, I wanted to fuck somebody's life up. I wanted to make the police station feel the burn. The thought of me beating somebody up or shooting somebody is the only thing to soothe my soul at that moment. And y'all all heard those directly out of his mouth. So, what do Infinger and Morris say? Now, they're at the MAG office. They don't have their video camera. There's no video cameras. We don't have any audio. And he says, I'm glad I shot him. I'm glad I shot him. Doesn't that sound just like something that would come out of the mouth of a man who says, the only thing that soothes my soul, that brings me peace, was to shoot somebody? I think the evidence shows that it does. And when he says, you can't judge me, go back to see what he tells Duke. He says, I want to feel for the family, but something in my heart just won't let me. Something in my heart just won't let me feel for the family after I pump 2 rounds into that man's head. It felt good to do what I did. Again, perfectly consistent with somebody who's going to say, the only thing that soothes my soul at that moment is to shoot somebody. And that I had to do something to get someone to listen. Well, he tells Detective Duke, the only way to pay back society was to lash out. I guess he got our attention. So I want to make sure I go over this before I say a few more things. This is the charge of the court. This is the law that you're going to be given. Like I said, I think this is you couldn't get a more obvious case. This is not a whodunit. This was an intentional and knowing killing of a police officer. He was obviously a police officer. He knew he was a police officer because he told you, that's why I killed him. That's why I killed him. Because he was a police officer. And he was acting in the lawful course of his duties, and it occurred in Bexar County, Texas, and he used a firearm, a deadly weapon. Obviously. You saw what he did. You heard Dr. Simon talking about how blood was gushing out of his gunshot wound to his head. You heard her say, the first wound, if that wasn't bad enough, destroying his palate and his tongue, he may have been able to survive it. But she told you, he certainly felt it. He felt that shot. He felt the pain. He was still conscious. If you watch the video, you see Detective Marconi's left hand come up to his face. Intentionally knowing the murder of a peace officer, acting in the lawful discharge of an official duty, and he knows he was a peace officer. This is a very simple charge if you pay attention to the evidence and what you have before you. The only time, and there is a murder, they got a lesser included murder charge in here, because if you think, well, because he'd been texting earlier in the day that he really wasn't acting as a police officer at the time he was killed, then you can consider the murder charge. And that's the only way you can consider the murder charge. You consider the capital murder charge first. If you find him guilty beyond a reasonable doubt, all 12 of you, of the capital murder, you don't even go to the murder charge. We've dealt with his statements to Detective Duke. Just a few things. This inquiry we always talked about. I think we told all of you back in jury selection. Obviously, y'all couldn't be witnesses. If y'all were witnesses to what happened on November 20th, 2016, you couldn't be a juror. We said, necessarily in any trial, it's an attempt to recreate the reality of what happened back that day, on that day. And this trial began, and we were put to our proof to prove this case beyond a reasonable doubt and to bring you everything we had, because at the beginning of this case, he stood up and told you he was not guilty. So now, we're put to our proof, and I believe that we have proven our case beyond a reasonable doubt. This inquiry into the truth and justice of what really happened on November 20th, 2016 began with Detective Marconi being cowardly ambushed and publicly executed. And then we have the issue of, was it, they could say, well, was that really Otis McKane? How can you prove it was Otis McKane? If it was really Otis McKane that did this, you'd be able to show that car that everybody talks about, that was his car. You'd be able to show that. Well, we did. And I think y'all can all remember the numerous people who came in, including, remember what he said to Detective Duke? Including his own family. They were blowing up his phone. His own family knew that. So don't you think he and his new wife, they got married the next day after he commits a capital murder, you think they were aware? His family's calling and saying, man, that's your car. That's you. And he even says to Duke, remember this? He said, you mean just because that car looks like mine and that person looks exactly like me, that's the only reason you're considering charging me? So we went beyond that. The rent-a-tire people, and this is one thing I do want to say before I forget. There was a famous case years ago, the Kitty Genovese case, where a woman was killed in New York City, and they were probably...
relevance, Your Honor. It's not a reasonable deduction from the
Using
evidence.
an analogy, Judge.
It's not a reasonable deduction from the evidence, and it's not a plea to law enforcement, and it's not for the facts of this case.
You should be proud of your community. People cared, and they got involved. It shows what a tribute the military is to this community. Think of all the people who saw what happened and stopped and tried to render aid, or they came into this courtroom and had to take the stand and go through what some of them had to go through. San Antonio, Bexar County has some extremely fine people here. And the military, obviously, Dr. Simon, all of these people care, and they cared about what happened to Ben Marconi. And you should be proud that you have people willing to step up and come in and tell what they saw, because a lot of people, frankly, are afraid to come in a case like this. They don't want their faces on TV or in the newspaper. So, we tie him to the car. The rent-a-car guys, all three of them say, we saw it on the news that night, and it was that guy. And you know how they knew it was that guy? Because he'd just been in 2 days before. And what does he say? Oh, I'm trying out for the Spurs D-League team. And what does he tell Detective Duke? I'm trying out for the Spurs D-League team. He always dresses the way he did on the day he killed Detective Marconi. They saw him at least 8 to 9 times because he'd come in and pay cash every Friday for those rims. And then you saw the video of him getting out of that car, that same car that we showed you was full of what? Receipts from Rent-A-Tire. And you saw him carry those boots that were found in his apartment, and you saw that the rims, the original rims from that Mitsubishi, it's hard to say, are found in his apartment. And what else is found in his apartment? Those shoes. Look at the shoes he was wearing with the little silver tab, the black Air Jordans with the little silver tab. He's wearing those when he comes into the lobby. He's actually, if you look closely enough, he's wearing those at the hotel that night, at the Econo Lodge. Same shoes. So, you have the Rent-A-Tire guys. All three of them come in and say, and these are people that don't know him that well. And that knew immediately, that's him and that's his car. Can you imagine why his own family was blowing up his phone? They knew it was him. They knew it was him. And then somebody may say, well, if it was really him, wouldn't they have a confession from him setting out exactly what he did? Well, we do. And in excruciating detail, finally, after all the lies, he says what happened. And one of the reasons, apparently, he says it is, I know I could get a lethal injection for this, so I hope somebody has mercy on me. He knew the price of poker for what he did to Detective Marconi. And then somebody could say, well, you know what, if it was really him, maybe he'd say something else to somebody else besides the police. Like maybe the media. Well, he did. We know that. Y'all all saw him when he's coming through the garage. And it wasn't the police officers asking him questions. It was the media. And you all heard what he said. And then somebody may say, well, you know, okay, the police, the media. You got anybody else that he may have said something to? And we brought in Elroy Brown, the mental health therapist, who told you he was rationally thinking, wasn't suffering from psychosis, wasn't suffering from mania, understood the questions, and he tells Elroy Brown, yes, I killed that police officer. I did it because of the uniform. I was striking out at the system. I guess the last thing I want to leave y'all with is that there's an old saying about a duck. If it walks like a duck, looks like a duck, quacks like a duck, it's a duck. Well, in this case, we have all those, and we have the duck saying to you, by the way, I'm a duck. We have this man who, on the video, you see, he walked like a killer. Remember when he sneaks, when he drives up from behind, the thing that gave Mike Garcia such a problem, drew his attention, and he is running like this, sneaking up on him. So he walks or he runs like a killer. He acts like a killer when he sticks that left arm in there and 2 times shoots him in the head twice. He talks like a killer. Y'all all heard what he said on the confession. And then lastly, like the duck, he tells you, I'm a killer. Ladies and gentlemen, we have proven beyond what I would say is all doubt that Otis Tyrone McKane intentionally and knowingly on November 20th, 2016 didn't even have the guts to look Marconi in the face. Pumps 2 bullets into his head. Oh, and lastly, before I forget, somebody may say, well, what about any eyewitnesses? Do you have any eyewitnesses who said he did it? Well, Mike Garcia, who was going into the Army, said it was a cowardly execution. Kevin Wilkinson, who was working the fishbowl that morning, had been a civilian for 8 years at the San Antonio Police Department, says that's the man that came in at 7:30 that morning. Juan Encino, the VIA bus driver, comes in and tells you, you know what, I'm 80% certain, but I really need to see the whole body, which really, if you think about it, makes sense. I mean, you want to be fair to somebody. When he sees the whole body, yes, that's him. Now, they may say, you know what, that camera on the VIA bus, but where's that? Well, sometimes technology doesn't work like you want it to. I think we've seen that plenty of times in this courtroom. Sometimes it doesn't work. And then you had Alexander Patterson, who told you, I locked eyes with this man. I locked eyes with this man, and I will never, ever forget those eyes. Detective Marconi never had that opportunity. Never even had a chance to defend himself. At the conclusion of this case, we're going to ask you for a verdict of guilty because he is guilty of capital murder of Detective Benjamin Marconi.
Will you please court, Your Honor?
Yes.
Counsel. Well, I don't have a duck joke for y'all, but I do want to say that the defense does appreciate your time. I know that it's been a long time that y'all have been away from your family, from work, from kids, from your lives, really. So we appreciate the time. I know that y'all heard a lot of testimony, some emotional stuff. We appreciate that. what I want to first off do is I want to start off by kind of demystifying the jury charge. That's going to be my time with y'all, and Mr. Bettis will come up and argue the case to y'all. Okay, but sometimes y'all have copies there with you. You don't have them now, I noticed, but you will certainly get them, I'm sure, when you get back to the jury room. But this is the jury charge. It essentially is the judge instructing y'all and telling y'all what the law applicable to this capital murder case is. Okay. What I usually do is I usually start off by numbering it. So I would encourage y'all to do that. It's 1 through 11. I'm just going to kind of go through it real quick and kind of explain some concepts to y'all. So start off here with the caption. That's just the case, his name, the cause number, and that kind of stuff. You come down here, you'll see the law on capital murder and then murder, right? And if we go all the way back to Boyer Dyer, right? Way back like over a year ago, right? A year and a half ago or something like that. The state instructed y'all or told y'all that capital murder is basically like murder plus, right? Murder plus. I'm sure y'all remember that, right? So it's murder plus the murder of a police officer, right, is what makes it, right? And when you murder a police officer who is acting in the lawful discharge of an official duty, that's what makes it, that's what the capital part, right? And unless the state proves to y'all each and every element of capital murder beyond a reasonable doubt, including the lawful discharge of an official duty, then y'all can't find Mr. McKane guilty of capital murder, right? We submit to y'all that they have not. So that would be page 1. We go on to page 2. Page 2 is simple. It's basically a glossary. It's not an alphabetical order, but it's basically a glossary of terms that y'all need in order to decide the case, right? So it has stuff in there like what an individual is, what a peace officer is, what a deadly weapon is, firearm, that kind of stuff. And then at the bottom, it's going to have what the state of mind instructions are. So intentional and knowingly, that kind of stuff, right? So page 2 is easy. It's just basically a glossary. We encourage y'all to use it. So if we go through it, page 3 and 4 are going to be what are called application paragraphs, right? Application paragraphs. And that has the law on capital murder and then murder. And murder would be the lesser included offense, right? Those 2 pages go along with page 11 as to what to use for the actual verdict, right? To make y'all's actual decision, right? So that would be page 11. So under each charge, right? First one says, we the jury find the defendant not guilty. Second one says guilty of capital murder. And third says the lesser included offense of murder, right? On the murder and the capital murder charge, submit to y'all, there are 3 choices, right? There's guilty, there's not guilty. But if we also submit to y'all that there's also unsure. And I would suggest that if it's unsure, it's not guilty. Skip back through, we go to we go on to page 5. That's going to be the instruction that the judge was talking about, and Mario hit on a little bit about the if y'all feel like the confession was taken in violation of Mr. McKane's constitutional rights, right? And we all have those same constitutional rights. The constitutional right to remain silent. It's a little bit of an issue during the time that Detective Duke talked to y'all. The top paragraph here says that basically if y'all feel like that confession was taken in violation of his constitutional rights, then you just don't consider it. And again, we submit to y'all that it was, and we ask y'all to not consider it. Below that would be page 5 on paragraph 7. That's what's going to be called an extraneous offense instruction. It's going to tell you in there that there may be some things that you heard, like other offenses besides the capital murder that happened in the past, right? If those things help y'all, like in context, they're contextual, and they help y'all decide the case, then you consider them, right? But you don't consider them for other reasons. In other words, and that's kind of the idea where we don't convict people in these courts, or really in any court, for just being a criminal generally or just being a bad person, right? So if y'all feel like he's done stuff in the past, aside from this case, and it does not help y'all in context decide this case, then you just don't consider that stuff at all. And that's the judge is telling you all that stuff, right? So moving right along, page 8 is going to be what's called the Fifth Amendment instruction. Now, this basically, he didn't testify, right? And we all have, again, that same constitutional right under the Fifth Amendment, right, to not testify, to remain silent. And that's an awkward thing, and I acknowledge that, right? In everyday life, as humans, we want to hear people talk. We want to hear people tell their side of the story, right? But he has a right to not do that. And you know, the judge has told you, and our law says that you cannot consider the fact that he did not testify really for any purposes. And, you know, it would be a thing where, and it just goes back to the thing where, you know, let's just say, I don't know, a spouse goes out and has a big party at their house or something like that, and the wife comes home or parents come home or whatever, and you know, a kid has a party, and the kid, the spouse or the parents are like, what happened? Did y'all have a big party? And the husband or the wife or whatever, the kid wants to not say anything. It's like Fifth Amendment, Fifth Amendment. It's an awkward thing to do. It doesn't work there, but it definitely, you know, is something that we can do here. And you know, if the defendant doesn't testify, then you're not to consider it. So, moving on, the rest is kind of downhill from here, right? So, written statements made by witnesses to investigators, offense reports, none of that stuff is admissible. So if it didn't come in, if Mary didn't take the evidence, the judge didn't admit it and Mary didn't put it in this box here, it's basically something that is not part of the evidence. And again, y'all don't consider it. Now, what usually happens, I'm pretty sure it'll happen in this case, is this box, all the evidence will most likely go back there with y'all, right? So if it's not in here, it's not admitted, and y'all just don't consider it. Let's see what else we have. There's also an instruction in here to not communicate with basically anybody but the bailiff. I think sometime the judge, somebody was talking about once how people sometimes, like jurors will search through and look for definitions and stuff that aren't in your glossary. That's not permitted. Just so y'all know. I know y'all probably won't do that, but I just thought I'd bring it up. There's also an instruction in here about sympathy. Sympathy is not to play any role in anything that we have going on here. It can't play a part in your deliberations. This is an objective standard that has to be that your decision has to be reached upon, and you can't speculate as to how people would feel if y'all return a verdict of not guilty, right, or a verdict of a lesser included on murder. We just can't let sympathy, prejudice, bias, anything like that play a part in any of our decisions. And again, that goes all the way back to Fort Dyer. And finally, the judge has also instructed y'all that the burden of proof in the criminal court is beyond a reasonable doubt, proof beyond a reasonable doubt. That's the highest burden of the land. And unless and until the prosecution proves that Mr. McKane is guilty of capital murder, unless they prove each and every element beyond a reasonable doubt to y'all, you can't find him guilty. So if we take it as like a sliding scale, right, we go from the left to the right. We'd start with way on the bottom, traffic stop stuff, right? Call that reasonable suspicion. Very, very bottom. They just have to have cops have to have a hunch, basically, right? A hunch to pull you over. So that'd be way down here. After that, we start with, we go up to probable cause, which is what I think y'all heard, or there might have been evidence. I'm pretty sure y'all heard evidence in the record about how that's what you need to get a warrant, probable cause. It's maybe police officers can come together and have articulable facts and kind of discuss them with each other. And if they feel like it's more likely than not that something's happening, there's some kind of criminal conduct amiss, then that meets the standard. Probable cause. It's a low standard, very low standard of proof. Higher than that would be the preponderance of the evidence. That's what people use to take, or what the courts or what a jury would use to decide. That's the burden of proof, to take people's money, right? Money in civil court, right? So Thomas J. Henry kind of stuff, right? Car accidents, that kind of stuff. That's still not what we're dealing with here. That'd be about 50% and a hair, right? Is what they are, a feather or whatever. So just a little bit more likely than not. Clear and convincing evidence, that's way over here, right? That's what's used to take people's children away. To take your children is clear and convincing evidence. I'm talking about in criminal court, what we're dealing with right here, it's beyond a reasonable doubt. That's the highest burden of the land. That's way over here, right? That's way over here. And that presumption of innocence that we talked about way back in Fort Dyer, that stays intact. That's still intact with this man, right? And that continues with him. It remains intact And it continues with them until each and every element of the offense is proven to y'all beyond a reasonable doubt. We submit that it hasn't, and for that reason, we'd ask you to find him not guilty. Thank you.
May I please report, state? I want to thank you for your attention to this case, ladies and gentlemen. I can tell you all were writing notes. You've been very, very attentive, and really, thank you. I want to talk a little bit about, start with way back at the voir dire, when we were selecting all of you. And if you recall, the state would put up, and it would say, these are the elements of murder, right? And then at some point, they would say, and this is what changes it to capital murder. And in the case of a peace officer, is that he was a peace officer, but that wasn't the only thing. It was that he was acting in the lawful discharge of an official duty. Okay? And there's terms of art there. The legislature didn't just place them there for the hell of it. They're there for a reason. And I just want you to keep in mind as I go through some of this. The state also told you, they would say, we have the burden of production. That is to say, they have the burden to bring the evidence. They have the burden of persuasion. They have to convince you. And they also have the burden of proof, which is the amount of the convincing nature of what they have to do. Mr. Lagasa just mentioned the taking your kids away by clear and convincing evidence. Think about the amount of proof that you would want before the state of Texas could take your kids away. Because I guarantee you there's nothing much more than what we value our children. Okay? Just think about that amount of proof. Now, let's talk about the investigation. The amount of evidence, the 2 weeks, the 350 exhibits, everyone told you the amount of agencies involved. TABC, the Texas Alcohol and Beverage Commission, what do they have to do with a murder? They got involved. The FBI generally doesn't have state jurisdiction. They got involved. The United States Marshals don't have general jurisdiction. They got involved. They said that San Antonio has 40 CSIs, crime scene investigators. They brought 26 of them. I just want to suggest to you the amount of investigation that went into this case, merely because Officer Marconi was a police officer. That not might happen in a murder of a regular citizen. And by that I mean a non-police officer, a non-protected person. You know what I mean? One of the officers, not one, several of them said, I was finishing an investigation and I heard it on the radio and I went over there. And those several officers that said that, Deputy Chief Salas, I think, was one, he said, I was investigating an officer-involved shooting. That's what his report said at the time that he made it. But when he came to testify to you, he says, I was at Jimmy John's. No, he dropped that investigation because it's an officer. The jury heard the evidence. You can decide whether I'm misleading you or not. I don't think so. But the other officer, Lopez, his report said, I was investigating an assault on a citizen. That's what it said. I was investigating. I am investigating. And I heard it on the radio, and I left. But when he testified to you guys, he says, I was walking out in the parking lot leaving. No, what happened is everybody dropped what they were doing because, as Officer Lopez told you, it was one of our own. Okay? We have certain testimony that is, even though we do have video evidence, okay, but the way the state presented their case, they had witnesses that were contradicting themselves. The Villabus said, I pressed the button to record. No video. They put up pictures where there were everyone, I think it was the Pattersons and the bus driver, and they were like, was anything in the way? Oh, no. And they showed the picture. You see how there's no trees? But The gentleman with the red Charger or orange Charger, right there is where he pointed. This is where I slowed down and I almost came to a stop. They knew he was going to say that, and nobody mentioned it until we brought it up, that there was an impediment to some of the view. And I don't know if people wanted to come in and say, I don't know, some things of self-importance. I'm not trying to insult anybody. I'm just submitting to you certain things. That lady, I believe it was Miss Patterson, that came and said some very emotional things. That she saw the injury to Officer Marconi, that his eyes were lifeless. That she went and opened the patrol car's door. And I asked, and they put her on, and they let her say all those things to you, under oath. And when I got her on cross, I say, we have a video. You didn't get close to the car. Are you sure, under oath, that you opened the car to the patrol car as you are of everything else? She's like, oh, well, I don't know if she likes drama or whatever. The daughter that came in, she never mentioned the red Charger. According to her, there was no impediment. A very important thing. Ricky, I don't remember his last name right now. The gentleman was pulled over on the red car. He said when he went over, he said Marconi had something in his hand. And he thought it was his driver's license. Okay? Well, we come to find out it wasn't his driver's license. Whatever Marconi had in his hand, it wasn't his driver's license, because we know that CSI Oliva went and got it on video on her body cam. You can see that. She got it from the MDT, the mobile data terminal, and she picked it up from the keys, even though she's not supposed to do that because that's a crime scene. Okay? You know, they keep talking about this double blind, that we're trying to protect the integrity of IDs. But remember, they very quickly put out the pictures of the guy, not his driver's license. Don't get me wrong. To be fair, because Duke said, I think at some point, we didn't put out his driver's license, and worse, someone in the police department leaked it, because only cops had this information, and they leaked it to the public. So now they'd already distributed it to all of PD. You think they're going to give it to only certain cops? Everyone's investigating this, and yet they send detectives supposedly to do a double blind. And the double blind ID, if you didn't catch it, is I'm supposed to be a cop, which a lot of times happens, detective, and I'm investigating this over here, but I don't know anything about that case over there, like the detectives do over there, who the suspect is or whatever. And they say, hey, Joel, you come over here and go do the double blind, because I don't know who the suspect is. So it adds integrity. You see what I'm saying? It had some sort of integrity, but in this case, everybody knew. Everybody knew. They had the pictures. Yet, there's Duke, Detective Duke, going with that other detective, and Duke knew the identity of the guy by this time, and yet Duke still goes. And to avoid any conflict, he goes, well, I came over here to the living room because the ID was going on in the kitchen. Well, why go in the first place? Why go in the first place? Why create that appearance of impropriety? Detective Barnes went to another, Rachel Barnes, I think was her name. She went to another supposed double blind. Well, number one, the pictures had already been distributed. Okay? The pictures have already been distributed. And she said also, I was by myself. Okay? And forgive me, I don't remember the name of that witness, but he says, and the two guys, he said this, I said, wait a minute, there was only one woman there. Oh, no, there were two other male detectives. And they talked to you? Yes. What's up with that? So what I'm suggesting to you is the investigation that the police did is not always the way the state presents it to you. Okay? because there are issues that come up. You know, they go as far as to bring in DPS airplanes. Maybe they had choppers up at first. I don't know. They bring in NASA photos. Think about it. They bring in NASA. These are guys that it's a science that is used, that God knows how many millions or billions of dollars have been invested to produce that. And they bring it in this case. And I've been doing this 32 years, and I have never, ever, ever seen that. And I'm going to make a point of that in a minute. There's various descriptions from different witnesses describe the gentleman differently. Okay? And maybe I'm wrong, but on the pictures of the paint over the vehicle, it appears to be at different places in different photos. But you have the evidence, you review it, okay? Just that's something I observed. Let's move to the voluntary statement, supposedly, the statement he made to Detective Duke. I do not question Detective Duke's integrity. He is a man of honor, okay? I do question police tactics and police techniques, and I told him that. I know Detective Duke, okay? Now, I understand that the law permits some things sometimes, but the law is not always right. Sometimes somebody's got to say, that just isn't right. In the fact that police are allowed to question to citizens, that's something that you, when you consider the voluntariness of the statement, you have to consider. Because there's people of all sorts. Yes, maybe in Mr. McKane's case, did it appear high? I don't know. I can see a guy that, if I see you, and not you, sir, I'm sorry, but if I see you and you've had 2 beers, I might not be able to tell if you've had 2 beers. You know, people take Xanax and it's called a certain word. I forget what it's called, but you know, I might not realize that they're on Xanax. I'm not a doctor. I'm not a psychologist or a psychiatrist. And not only that, you have people in different emotional states. You have people of different psychological IQ, mental IQ. You have people that have emotional, depression, whatever. You know, there's I think it was Plato, where he said, "Be kind, for everyone you meet is fighting the hard battle." And what that means is you don't know what people are going through. And I think some of that applies in this case when the police are allowed to lie to you, to tell you, I've had cases where they say, we have your fingerprints in the woman's throat.
I would object to an argument outside the record.
I'll withdraw that. That's fine. But in this case, let's see. We have your fingerprints at the entrance to the police department. We have your fingerprints on the patrol car. We have 15 witnesses that saw this, implying that they have 15 witnesses that ID'd him. The chief at the very beginning coming in, "Oh, sir, what is your complaint? We're going to get to the bottom of this." It's all trickery that they do not only on McKane, on citizens. Okay? And who can it ensnare? I couldn't tell you. But I would submit to you that that's wrong. We argued a lot about the waiver. And we've seen it since Perry Mason and Adam 12, for those of us that are older. it just shows from before law and order. You have the right to remain silent. If you want, can be not afforded, et cetera, et cetera, et cetera. And they're right. The law does allow that the express question of, do you waive those rights? The law has said if the guy starts talking, okay. However, again, it comes where you have decided to decide if for that individual it made that statement involuntary. And Detective Duke, to his credit, because again, I've told you, I do not question his integrity. He said honestly, he says, well, something along the lines, I'm not going to quote him. Well, because if you ask that last question, do you waive? The guy might go, no, I don't waive. And now that's it. They can't get a statement, So if you say, do you understand your rights? Yes. And in this case, Duke, I think I've said to him, there's different ways of how they do it, because they say, those are your rights, et cetera, et cetera. Do you understand your rights? Yes. And wham, like that, they transition to someone else. Oh, well, let me talk to you about your mom. Oh, well, let me bring up this. In this case, he switched and transitioned very quickly to, that's what they should have done out there in the field. That's what they should have done. Because they don't give a guy a chance to think, well, do I want to waive them? And it's up to you. You have to decide. And the charge tells you that they have to prove to you that the statement was voluntarily given. That his rights, that he understood them, that he waived them. And they have to prove that to you, not with some willy-nilly standard. They have to prove that to you beyond a reasonable doubt. They have to exclude for you every single doubt that is reasonable, that you say, man, did that guy really waive his rights? And if you don't believe that he really voluntarily waived his rights because of this design in the system that they have, then you can say, and the law says, this judge says, you can't consider that statement. You had to say, no, we're not going to consider. Everything he said is out the window. We're not going to consider it. If you find, because remember, through the voir dire, and this judge is telling you, the defense never has a burden. They have the burden of proving to you everything in this court beyond a reasonable doubt, just as Mr. Daniel de la Garza told you a second ago, and it goes from reasonable suspicion to probable cause to preponderance to clear and convincing. And like I said, preponderance, I mean, just very briefly, isn't like in a car accident. What's the evidence in a preponderance? Who was at fault? What's at stake? Money, right? Do I get my car fixed or what? So we allow whoever convinces you 51%, they win. Clear and convincing, I already mentioned to you, is where the state wants to take away my kids, your kids. And you have to ask yourself, what kind of proof would I want for them to take away my kids? And here, this court tells you beyond the reasonable doubt is higher. They have to exclude every other reasonable way that this thing could have gone down. And it's up to them. And I submit to you that in this case, this statement was not voluntary, because if they had asked them, if Detective Duke had not transitioned like that, Mr. McKane would have said, wait, I don't wait. Okay? And then there's and Detective Duke said, yeah, not similar, but I had trouble with my kids, I believe them. I'm divorced. It's not the prettiest thing, But then he goes into like, man, you could have had her arrested when she tried to run you over. And it's false empathy, false sympathy, whatever you want to call it. They talk about that maybe women are bitches, It's like to get on his good graces. And, like I said, it's the psychological effect that it has on your average Joe out there that's not very educated. And these officers have 25 years of experience. They go way a long time ago to that 40-hour class on interrogating, on trickery, on lies, on mental, I don't know, whatever it is, you know. And then they go to continuing classes, and not to mention that they're constantly doing it to one guy and another woman and another older guy and another younger kid, and they start getting real good at it, okay? But that's up to you, and I submit to you that if you that you should find that the statement is not voluntarily made. Now, if we go now and fast forward to the extra statements, I'm going to call them extra statements, okay? And I'm talking about the ones that they're attributing to the magistrate court, the detention facility. You know, they transferred them from over there. Okay, now, a couple of things are missing. When they transport him from the arrest scene over there off of I-10 and 1516, and they bring him in this car. Now, we know from Marconi's car that they have the Coban, but they also have that camera in the back. And you know the purpose of that camera is to observe a prisoner. So if he starts banging his head against that whatever chain, it's not a chain link fence, but whatever it is that keeps you from hurting the officers, you know, they'll have it. You know, if he starts screaming, going crazy, they have it. Well, the units have that. And then this is a capital murder of a police officer, and because now in that video supposedly is where Enfinger says, oh, he glanced over there very suspiciously. Well, guess what? You all don't have that video, okay? Mysteriously, it's not there. And no one testified whether they looked for it or not. Enfinger said, I just don't know. Well, who was the evidence tech that was responsible? So at least we can rake them through the coals, you know? They didn't bring them. And remember, the burden's not us, okay? I want to make sure that you always remember it's not your job to do that. It was their job to do it, okay? Now, we have the officer, Parker Morris, the young officer that came in. And he said, and I used this language at some point, I said, well, so he said it he barely said it. And they jumped up, that's not what he said. And I don't know, to me, a guy says, hey, he said something under his breath. To me, it's like when you're in school and you go, bullshit. It's like, it's under your breath. People go, did he say BS? What did he say? You're not sure. So Parker Morris heard something under his breath. He goes as far as to say, I'm not sure that he really didn't intend for me to hear it. That's how low it was, okay? He said that I thought he was on arm's length when I was standing next to him, if you recall. I said, were you this far? He goes, no. He was like right here, because this is McKane. He was right here because he was patting him down, okay? So he's right there, and I think at the time he said he was like down here, the legs or whatever. But you'll remember the evidence, okay, if I'm wrong in something. In his statement that was under his breath was, it felt good to shoot him or to kill him, okay? And the question is, how sure are we that that's what was said? When it's said under your breath. How many times in your lives has someone said something under their breath and you go, did you say? And they go, no. What I said is this. Oh, I thought I heard that. That's what happens when people speak under their breath. Now, by the way, to be fair, rightly or wrongly, Officer Morris, this happened in 2016. I think you go to the academy like a year. So 2017 passed. He says, hey, this guy said that, and it's an alleged cop killer. And guess what? Now I'm in the academy. Now I'm a cop. Now he's rewarded. Whether it was for that or not, I couldn't tell you, but it's something that you ought to consider. I don't know, okay? The guy in the bubble says he saw him, whatever. Now he's a cop. One of the tire rent-a-car guys, now he works for the city of San Antonio. Some of the officers that were sergeants that were involved in this case, now they're lieutenants. So I don't know if everyone that had something to add or something, something good happened to them, But that's something for you to consider. Now, then we go to Officer Enfinger. Now, the thing about Officer Enfinger, the first thing you should notice is, that place where they're bringing Mr. McKane out is a secure parking lot. You and I couldn't just drive in there. The media just generally doesn't drive in there, but they bring him in because I guess now Mr. McKane is a trophy or something. I don't know. And they want him to be paraded in front of the cameras. And just like he started saying to Detective Duke, I want to apologize to all of you guys in the police department. It was the worst mistake I ever made. I took it out on someone that didn't deserve it. Okay? Once he came clean, he came clean. Now, he comes out now to the media and he says the same things along the same lines. I was frustrated about my visitation, XYZ. Now then magically, that ride, which, by the way, that ride, and I showed it to you all, you come out of the back of the police department, you take a little left, and you take a right, and you're right there. It's like 2-3 blocks away. But what they do is they parade them. They parade them like a trophy around the police department and then come over here. And when they're pulling up, there's all this bike patrols there. It's like, again, like he's a trophy. Now, remember, they have their mics on. They didn't have body cams on, but they have those mics, okay? They're picking up the audio. Well, when they get there, he said, I turned it off. Well, they had him on because they were waiting to see if McKane said anything. I would submit to you that once he gets there and now McKane has not said anything, he turns it off. Because now you can attribute statements to McKane that are not going to be on audio. Now, he said his rationale was, it was common practice to turn him off. Well, where's the policy? Nothing cops do is common practice. I brought up at some point their union contract. They have so many rules. I brought it up in evidence, Your Honor. Okay, they have mics. He attributed to common practice. Okay, but let me tell you another thing. Why did he turn it off, he said? Because there's cameras everywhere, he said. And as you're driving in, you see on the coal van, there's a camera outside. You don't think they have cameras inside? Where, remember the other officer? I don't know if it was Enfinger, but one of the officers testified, hey, when he's in my custody, I want to make sure that no one can accuse me of doing something. You think at the detention center, they take women in there. You think they don't have cameras and audio to make sure that any detention officer doesn't do anything wrong? Okay? And then Parker Morris says he said that under his breath. Did he really say that? I would submit to you that it doesn't follow reasoning and rationale and logic if what he's saying over there to Duke, what he's saying to the media, and then all of a sudden over here he changes his tune. But over here, we don't have it on audio and video. Okay? Now, we know that Enfinger, for lack of a better expression, was not being truthful. And the reason he's not being truthful is because Parker Morris said all the other people, all the other cops, while I was patting them down, were 10 to 15 feet away. Parker Morris barely heard whatever he heard. And I don't even know if he heard the right thing. Again, because when you speak under your breath, that's the idea. You're like, what did that guy say? You know? Sometimes it's you can be at a cafe and some guy says something like, did this guy just say something about my girlfriend? You know, I'm not just making that about criminal cases. I'm making it about your life. Kids saying something to parents. Did my kid just say that? You know, because you're not too sure when things are said under your breath. Now, what happened with Enfinger is he added, listen to what he added. That McKane said he was glad he shot him. You can't judge me. It felt good to do what I did. Now, how do you get that at 10 to 15 feet away when Parker, to a general extent, isn't even sure about what McKane said under his breath?
Object again, that's another misstatement of the testimony.
No,
Parker Moore said.
The jury will remember the evidence in this case.
he said it was under his breath. Unless they have a different definition of that, they can tell you the different definition of that. And so, Enfinger, it just, I don't know. I mean, I'm very careful about calling people liars, but he is sadly mistaken. And the state, they have the burden. They could have brought you evidence of, like, ladies and gentlemen, that place is full of video and audio, and that night there was a storm, whatever. They just didn't bring it to you. So you don't know. So when you don't know something, that's reasonable doubt. Okay? And there's things that you don't know because because it is. If you don't know, think about it. Would you have a reasonable doubt? You don't know where your kid is. Okay? I have reasonable doubt about where he is. If my girlfriend is cheating on me, I have a reasonable doubt if I don't know. No knowledge is reasonable doubt. Now, let's go to the issue of the texting. Okay? Now, remember, we did not introduce the video of the entire shift of Officer Marconi. They introduced it. They opened the door to that evidence. Okay? And there's this evidence of what's going on during the shift that began at 6:30 of Officer Marconi and his conduct while he's out on duty. Okay? Now, first of all, I want you to just think, this wasn't his regular job. He's a DI, a detective investigator. And that's why at the scene someone said he's a DI. They couldn't figure out why he's in the supervisor car, you know. So we know that he comes in regularly on Sundays. Now, it's a downtown assignment. It's a Sunday. Sundays are slow. People are going to church. You know, kids are hungover from Saturday. They're sleeping late. It's a cush assignment. Just go out, do a little patrolling, park here and there. And the proof is, because they introduced that video to you, that he does that. At different times, he parks. Now, the state made it out to be, stationary patrol. Deputy Chief Salas, I believe, said, officers like to watch if people are taking red lights and stop signs and all that. I said, no. If you look at the video, Officer Marconi has the stop sign. Everyone else has got the right of way, you know, and he does it twice. He parks one time, I think, for 35 minutes and another one for close to 45. Don't quote me on that. I may be wrong. But it was extensive periods of time. And during that time, he's texting. Okay? He's doing some texting. Now, we don't have the burden, remember. They have the burden to bring in you evidence. Now, what else? We have texting. What else is in there? Is there Google searches, FaceTime, any Imager, Reddit? I'm not very savvy on that. But there's a bunch of things that you're doing on phones that aren't texting. Okay? I have here that he stopped from 10:05 to 10:34. That's approximately 30 minutes. He's just parked right there on that side road. And then he parks also roughly, okay, don't get me wrong, from about 10:54 to 11:30 right before the stop. Now, we know the time of death is 11:38 and about 26, 27 seconds, okay? Now, once the incident happens, I want to make sure I mentioned something because it was said. Allie Jefferson said that officer was looking down like I was reading a text or a phone. She said that, okay? And I want you, if you have to, you can look at that. She said it looked like he was looking down at his phone while he was on the traffic stop, supposedly. Now, when officers go to the crime scene, in a crime scene, and I mentioned it to CSI Oliva, remember, once you have a crime scene, the general rule is you touch nothing because you want to preserve the evidence the way it is. I mean, literally, where everything is placed is significant, okay? So we know Officer Oliva went and took that driver's license. And, maybe she had... Okay. Believe me, look, I don't have a photogenic memory. I might be remembering things slightly wrong. But I promise you I'm not trying to mislead you. If I'm wrong, it's okay. So long as I'm in the ball field of maybe it was Officer Joe Blow, I don't know. Okay? But we know that officers were moving scenes, at things at the crime scene. Now, one of the things we know, if you look at the photographs, Officer Marconi is in the driver's seat bottom, where you would sit. Now, you know that Officer Marconi was not sitting on his phone while he's sitting there. It defies common sense. He was not sitting on the seat to his car. Someone put that phone there. Someone moved it. Okay? Now, we also know that Ricky said he saw something on Officer Marconi's hand. Now, he thought it was a driver's license. Okay, I don't know how traumatic it was to him to see something like that, but he said, I saw the driver's license on his phone. Well, what do we know? It's not the driver's license, because the driver's license is put on the MDT, that computer that cops use. That's where it was. Ricky's ID was there. So we know that Officer Marconi had something in his hand. And we know it wasn't the driver's license. And so we also know that the phone was moved without any question and placed there. And we don't know who moved it. That means you don't know who moved it. Okay? Now, we also know that the ticket book is on the dash of the car. Now, that car, because, again, something along the lines, I'm not telling you that cops don't do hard work, okay? But that assignment was kind of a cush job. It's a supervisor's car. That's not the regular car that Marconi would drive. Okay, because it's a DI. So that patrol car had the ticket book on the dash. If you look at the photos, the ticket book is on the dash. Okay? Now, we know that the timeline, if you bear with me because it's important, the timeline of the texting and the like. And before I get into that, look, let's say there's a law, which there will never be, but it becomes a law. You kill a lawyer in the discharge of his duties, it's a capital crime. But if I'm talking to my ex, I'm talking to my chicks on the phone, my daughters, a buddy, we're going to go drinking, we're going to go to the lake, that's not, I'm not acting in the lawful discharge of a lawyer. I'm trying to make a point. Not only for police officers, I don't care if it's a plumber. They made a law, if you kill a plumber while he's on duty, acting in the lawful discharge. And it's not like, oh, I go to work from 8 to 5, but I'm not always working as a lawyer. I'm not acting in the lawful discharges of an attorney from 8 to 5. There's just sometimes I'm not. I do private things. You know, my daughter's calling me about, hey, Daddy, I need you to sign a lease and send this form over there and money. It's like, oh, my God, I got to do this. You know, things like that happen. It's reality. And the same thing applies to police. And because they open their own door to the whole shift, we know that this officer in particular engaged in personal matters while he was on his shift. And during the times that he engaged in personal matters, he's not acting in the lawful. I have the indictment here. He has, not only does he have to be a peace officer, he has to be acting in the lawful discharge of an official duty. Think about what that, those words just weren't put by the legislature there for the hell of it. Acting in the lawful discharge of an official duty. Okay? And we're not saying that he was acting unlawfully. He wasn't smoking a joint. He wasn't doing cocaine. That's not what we're saying. But he was engaging in behavior that was not an official duty. He was acting not in the official duty. Now, the other thing I want to make real quick, we don't have to prove to you that he was on the cell phone. We don't have to prove to you that he wasn't reading, that he was reading Facebook. We don't have to prove to you that he was on Twitter or Imager or anything else. They have to prove that to you. And they have to prove it beyond a reasonable doubt. Okay? Now, just bear with me. We know that, and just if you can just listen to the sequence of events. At 11:32:05, Marconi ran the plates of the car. At 11:35, he's still after him. It's very common for police. If you know anything about practice of police officers, as they're going to pull you over, they run your plates. Okay? So at 11:32:05, he ran the plates. At 11:34, he pulls him over. Now, at 11:35:07, Officer Marconi returns to his patrol car. At 11:36 and 38 seconds, the return on Ricky Martinez comes. Okay, now he's got the return. Now, he is shot at 11:38:27. Between 11:36 and 38 and 11:38 and 27, that's, I think, a minute and 49 seconds. Now, remember that Officer Marconi, both at the stops that he did and during other times, he was engaging in personal matters on his cell with text that we could see. Now, we know, if we just do comparisons, at 11:30:53, Marconi sends a text. At 11:32:05, he runs the plates. At 11:34, 32 and 43 seconds, he receives a text. At 11:32 and 46, he receives another text. At 11:33 and 10, he receives another text. He pulls over the guy at 11:34. At 11:35 and 07, he's back sitting in the car. The return comes back at 11:36:08. Now, what I want to suggest to you, from 11:36:08, when he has the return, that's it. He's got all the information to write the ticket, if you will. That's a minute and 49 seconds. Okay. Now remember, we only know about the text because that's all we got. We don't know about FaceTime and all that stuff. But
That he was on FaceTime or Twitter or any of that.
it's a reasonable deduction from the evidence, Your Honor, that this officer engaged in personal business and personal matters on his cell phone while on duty, Your Honor.
It's asking the jury to make it up. There's
No,
evidence
no.
of it, Your Honor.
I'm going to overrule the objection, and the jury will remember the evidence, and they will make reasonable inferences therefrom.
Now, all I'm suggesting to you, if you look at that, remember, he goes to the car, he gets Ricky's DL, he comes back, the return comes. Okay, once the return comes, start writing the ticket. But I'm just going to suggest to you, it's an hour and 49 seconds. Now you think, that's not a long time, right? But remember, at that point, you can start writing the ticket. Let's see what a minute and 49 seconds is. Really. Because it's important. He could already be writing the ticket. And nothing is happening. Nothing is happening. Nothing is happening. That's 30 seconds. Why no ticket? Nothing is happening. It's a minute. It's in a minute and 30 seconds. It's a minute and 49 seconds, ladies and gentlemen. No ticket. Remember, we don't have to bring you the ticket. You're going to see in photographs, the ticket is on the dash. They could have brought you the ticket. Marconi could have been writing the guy's name, driver's license, whatever. Not a halfway written ticket. Nothing. They have to prove to you that at 11:38 and 27 seconds, he was acting in the lawful discharge of an official duty. Not that he was acting legally. I'm not saying, like I said, I want to make sure the lawful part, I'm not saying he did an illegal stop. I'm not saying he's doing smoking joints. I'm not saying he was doing coke. I'm not impugning Officer Marconi's character in any form or fashion. From all appearances, he was a good guy. All I'm suggesting to you, this is a court of law. And at voir dire, if you remember, the state would tell you, and if we fail to prove, they would tell you, because they would have the PowerPoint. We didn't have a PowerPoint. They had the PowerPoint say, and if we fail to prove to you one element of these things, acting under lawful discharge, Bear County, you taking an oath to follow the law. Back then it was you were taking an oath to tell the truth. But they locked you in. And now I'm locking you in. You said, and you told them, they said to you, if we fail to prove one of those things, because it's the law, where you follow your oath and find him not guilty of capital murder, and to a T, because not only to the 12 of you or 14 of you, because now we have 2 alternates, we went over like 160 people. They would ask everyone of that. And if someone said no, guess what? You're out of here. But you took an oath to yourselves, and you took an oath to this judge, that if they failed, and they challenged you, they said, we welcome the burden of proof. And we are telling you, we fail. Your duty is to find them not guilty. And I'm calling on your conscience and on your oath to yourselves, because we all have to look in the mirror, and on your oath to this judge. To really ask yourself, did the state prove to me at 11:38 was Officer Marconi in the acting in the lawful acting? Acting is not a state, okay? It's not like, oh, I'm a lawyer, that's a state. Marconi was a peace officer, that's a state. Acting is a fact question. And remember, whatever you do, don't shift the burden to us and say, well, did they really prove it? Did Mr. Perez or the defense really prove that Marconi was doing something other than this? No. You have to look to them and say, did you prove to us? Did you exclude every other reasonable thing that could have been happening? And they didn't. We had to bring the phone issue to you because they didn't want you to see it. Okay? And it is also not this. Well, I'm kind of sure he was acting in the lawful discharge. That's not beyond a reasonable doubt. If you say, well, I'm about 51% sure that Marconi was acting in the lawful discharge, that's not good enough according to your oaths. And all of you, we picked you because you're all intelligent people. Okay? If you say, well, I'm kind of clearly convinced that, he was acting in the law, that's not good enough. The law says that the state has to exclude every other reasonable thing that could have been happening.
I'm going to object. That's a misstatement of the law, Your Honor. That's not what the law says.
Okay, well, I'll read it. If I'm wrong, I'll correct myself, okay? Where is it? Hold on. Just give me 1 second. Okay. It says, it is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. Think about what that says. All reasonable doubt. All other things that could be reasonable. And I'm suggesting to you, they have not excluded the idea that it's reasonable. And you should have a doubt as to whether Marconi was not acting in the lawful discharge of his duty. There's such a thing as in baseball called the tie goes to the runner, where if you're on the fence, the benefit of the doubt inures to the defendant because he has no burden. So when in baseball, the runner kind of hits the base and kind of the ball comes in at the same time, the tie goes to the runner, and the runner is the defendant because we don't have the burden. And so we're asking you to return an appropriate verdict according to your oath that you took at Fort Dyer to tell the truth, and you all agreed with that, to your oath, to your own heart, to your own conscience, and your oath to this judge, and return a verdict of not guilty on capital murder. And then will be able to consider a guilty verdict on murder. Thank you very much, ladies and gentlemen.
Is everybody okay on the jury? Anybody require a break? Let's take a very short break. All right, the jury.
may be seated.
All right, State, you may proceed.
Thank you, Your Honor. May it please the court, counsel for the defense. Ladies and gentlemen of the jury. We sat for over an hour and listened to two of the defendant's attorneys talk to you. And not once did you hear anything about this defendant's actions. Remember? You didn't hear what Otis did, that he came to the police headquarters that morning. You didn't hear about Otis putting 2 bullets into Detective Marconi's head. You didn't hear about any of the statements that he made to Detective Duke. You didn't hear about what he did after he busted through those arms at the SAPD headquarters, right? And why didn't you? Why didn't they tell you about that? You know why. We all know why. Because if they talk about that, then they're talking about this defendant's guilt. Right? We saw it. This case is clear. It's straightforward. And we brought you the evidence through multiple witnesses about this defendant's actions and the statements he made about his actions. So if we get you to focus on anything else but Otis McKane, if we get you to focus on a conspiracy theory, right? If we get you to focus that Kevin Wilkinson, who just got out of the academy this year, had worked for the police as a civilian working the front desk, that some sort of conspiracy that he got accepted, because what did he do? Right afterwards, when he starts putting together the description of what he heard the shooter was wearing, and the description of the shooter, and he compares that in the car, and he compares that to what he saw that morning. Well, if you think about that, that goes to this defendant's guilt, right? And if you think about what Parker Morris says, but you know, Parker Morris, who was a detention guard at the time, and now he happens to be a police officer for 1 year, do you really think there's some conspiracy that they became police officers, that they made it through the rigorous academy and got accepted just because of what they did? No, absolutely not. They did the right thing at the time because it was the right thing to do. They notified their supervisors, but not because someday, years later, they would get some payoff and get to be a police officer. That's what they want you to focus on. And let's focus too. They want you to focus on that all these agencies are involved. The FBI, ATF, U.S. Marshals, right? And all the differences in the investigation, right? Because if you focus on that and the amount of resources that went into this, it takes your mind off of Otis McKane and what he did. And if you focus on the inconsistencies of the witnesses, right? It's been over 4 years. This family has been waiting for 4 years plus for justice. But if you focus on the witnesses' inconsistencies, Right? If you focus on that, you're not focusing on the defendant and his actions. And that's why we're here. That's why you're here. You're here because of what Otis McKane did on November the 20th of 2016. That's why you're here. That's why we're all here. And what do we know? Let's focus on his actions. And I'm going to take a minute through this PowerPoint and go through all of this defendant's actions so you can see. I know you've seen you've seen videos, you've seen pictures, you've seen other evidence. But it's time for you to see it. And when you go back there to deliberate, it'll be fresh on your mind. We know Otis McKane comes to the police headquarters on November 16th, on November 20th of 2016. He makes, and you'll have that video. Anything you want to see, it's for you to see. But he circles, he makes several laps around police headquarters. And he eventually parks in this back lot, which is the Bill Miller's employee parking lot. And you saw the video, he parks, he walks in, comes to the front door, and he's trying to get in. Kevin Wilkinson lets him in. And when he comes in, and he speaks to Kevin, who's sitting at this information desk. In one of the pictures, it's a closer view, you can actually see Kevin sitting at the desk. And he speaks to him, and he wants to have an officer come down, and he wants to make a report. And if you recall Kevin Wilkinson's testimony, what he says is, well, have you, a visitation violation report specifically is what the defendant wants to make. And so Kevin says to him, well, have you made reports in the past? And he said, well, it's been a couple of years. So Kevin calls upstairs. No one answers. I think they're doing roll call or something. And he says, well, let me get someone down for you. And what does the defendant say at that moment? No, never mind. I'll come back next week, right? That's what he says. That's what Kevin tells you he said. So he leaves. But he comes back. He goes for a couple hours. He walks out of the doors at 7:50 a.m. And we know he's back. And we know that from the video, and we know it from Alejandro Limon. He's driving that truck that's parked on Nueva, right there at Santa Rosa and Nueva. And Alejandro tells you that he sees the vehicle make the U-turn and pull up behind the officer. And several of these witnesses, some of them are thinking, oh, this must be an undercover cop, right? Because they know that it's not, that officers don't like it when someone pulls up behind them, right? It makes them uncomfortable maybe, I guess for officer safety, right? And so Alejandro Limon is focused on the defendant's car. And he makes the U-turn. And what is Detective Marconi doing? He's looking up Ricky Martinez's information on the license plate number. We know through the pictures, you've seen the pictures, this is Ricky Martinez's license plate. This is the screen that's up as Detective Marconi is being pulled from the inside, the driver's seat of that patrol car, pulled out, laid on the ground, and first aid is given to him. This is what's up. This is what he's doing. And there has been, I don't know how long it went on about all the text messages and stuff that Detective Marconi received. We know from the testimony, and the defense said the state didn't want you to have it. Well, guess what? We don't think it's relevant. We don't think the fact that he sent a text message at 11:30 a.m. before he came out of that alley and followed, or I guess saw Ricky Martinez's traffic violation, which is his tail light was out. The fact that he sent a message, a personal message, at 11:30 a.m. is not relevant. And what else do we know? We know from Detective Duke that there is no prohibition against officers sending or receiving personal text messages. And we know from Detective Duke, too, who looked at the records, that Detective Marconi receives 3 more, kind of back to back, 11:32 and some seconds, 11:32 and some more seconds, and a few seconds later, 11:33 and 10 seconds. But there is no evidence whatsoever that Detective Marconi saw those or he read those. We have no evidence of that. It doesn't indicate in any way if he's read them or saw them. And if he did see them, so what? We know from every witness who's testified, every officer who's testified, that we ask the question, when an officer of the San Antonio Police Department pulls someone over on a traffic stop, are they acting in the lawful discharge of an official duty?
That was not admitted in this court. It's a misstatement that we have issue on. We did not allow it specifically as to Officer Marconi.
Overrule.
You heard it from multiple police officers, including higher ups, the higher up ranks, that when a San Antonio police officer is conducting a traffic stop, pulling someone over on a traffic stop, that they are acting in the lawful discharge of an official duty. You heard that multiple times. And there's no evidence that's against that. They didn't bring you, and I know the burden stays with us. I want to make that clear. The burden never shifts to the defense. But if there was evidence out there that wasn't the policy, that officers can engage in personal texts, and in this case, before he even made contact with Ricky, he sent a personal text. But there's no policy or prohibition against it. And if there was, I'm sure you would have heard it. But there's not, and that's the evidence before you. So what do we know? We know that, and you'll see the video. I'm going to show you the video next. And it's important that you watch this video. This is the video from the inside of Detective Marconi's patrol car. And what's important, and what I want you to focus, he made a big deal. Mr. Pettis made a big deal about the 1 minute and 49 seconds. And we all had to sit and wait, right? We had to wait while the clock went to 30 seconds, to 1 minute, 1 minute and 30 seconds, until it hit 1 minute and 49 seconds. But what's more important than that, than sitting here waiting, right, and kind of doing this little exercise, is actually watching the video of what's happening in Detective Marconi's patrol car at the time and right before he's executed. And you'll see, and I want you to focus. The reason why I'm telling you this now is I want you to focus on the screen, on his computer screen. There's multiple things, and you can see the screen changes. And there's multiple things that pop up. And so Detective Marconi is reading those things. And so the testimony of Alexandria Patterson that they brought up, he could have been looking at a phone or because he was looking down or something. There's no evidence that he was looking at his phone. You'll watch the screen, and you'll also see him hold up a ticket book. You'll see that in here, where he puts a ticket book down or has a ticket book in his hand. And so they told you, hey, look at the dashboard. There's a ticket book in the dashboard, and there's no evidence that he actually wrote a ticket. Well, take a look at State's Exhibit 62. Here's a ticket book that has Detective Marconi's blood all over it. In addition to the ticket book on the dashboard, take a look at this. And you'll see the ticket book, and you'll see him holding it in this video that I'm getting ready to show you. And this video is hard to watch. It's shocking. It's unspeakable. But it's what he did. It's why we're here. And look at the screen. I mean, different images are popping up. The time is 11:37:32 seconds. You can see, look, he picks up his ticket book, the one There's one from the passenger seat. And continue to watch the screen. He never knew what hit him. And here's the next video. I mean, this is evidence. This is for you to consider. This is for you to look at and to go back there and deliberate. And this is what happened. This is exactly what happened. The entire traffic stop is on video. It's right here for you to see. There's no evidence Detective Marconi was on Facebook, on Twitter. You know what those are? Those are distractions to get you to think about something else instead of focusing on what Detective Marconi is doing, that he was acting in the lawful discharge of an official duty. And if enough stuff gets thrown up there, maybe some of it will stick, right? That seems like a philosophy that we just watched. But there's no evidence of that. And that's what we all talk to you about over and over again in jury selection is the evidence. And that's what the verdict, your verdict, is based on the evidence that's presented to you in court under oath. And from watching the video, you know from the evidence and also from the full-on videos that the defendant then busts through the 2 traffic alarms on his way out. And go back, think about the eyewitnessing. And I'm putting this picture up for you to see what the witnesses saw. You heard from Juan Enciso. You saw from the front of the Coban, of Detective Marconi's Coban, his bus turning from Cesar Chavez going north on Santa Rosa, and next to him, in the inside lane, are the Pattersons, Jennifer and Alexandria Patterson. And Juan Enciso tells you that when he was shown a photo lineup the next day on Monday, which contained the defendant's picture, he said he wasn't certain. He said he was 80% sure because he wanted to see the person he saw was standing up, and he wanted to see his full body. So he didn't just say, oh, that's him, yeah, I'm going to get someone, I'm going to pick someone out. He wanted to be certain. And that's what we're about here. That's what our job and your job as jurors is, seeking the truth, finding the truth. And that's what Juan Enciso did when he said, you know what, I'm 80% sure, but I want to see a full body. And so when he came in court, he recognized the defendant, and he identified him as the person who shot Detective Marconi. And Alexandria Patterson, she was from Luling. She and her mom, they were in town for her grandmother's 90th birthday, as you recall, and they were driving by on their way to meet Tierra to have breakfast before they went back to town, before they went home. And so she said her mother's driving, so Alexandria is focused on what's happening. She's not distracted because she's not driving, so she's not having to pay attention. And like her mom said, her mom almost hit the bus because they're trying to watch and see what's going on. But Alexandria is focused. She's watching the defendant, and she watches him. She tells you he had a gun. She heard the 2 shots. She saw him shoot Detective Marconi. And in her statement that she gave immediately after they're brought upstairs, statements are taken from him, she tells the detective, if I see him again, I'll recognize him. I got a good look at him. If I see him again, I'll recognize him. Well, she came in court last week or 2 weeks ago, and she said, that's him. That is him. That is the man I saw shoot the officer. She told you that. And we asked how certain she was. She was certain. 100%. And Mike Flores, you heard from Mike Flores too. He's the gentleman who's going into the Army, who was driving the red Dodge Charger. And he was behind the Pattersons as they're turning. And so he says, I stop. Like I'm going 5 to 10 miles an hour and I kind of stop. And so he gets this perfect view. And the question about the trees, you see the pictures. There's big spaces between those trees. They're not bushes. The leaves are up top, right? You saw them. There was nothing that obstructed his view. So he tells the officers in his statement too, if I see a photo lineup, I can recognize this guy. Well, at the time these witnesses are giving their statements, there's not a suspect. And the reason why, it's like 12:30, 1 o'clock, an hour and a half after Detective Marconi was killed. And so they don't have a suspect. You know why they don't have a suspect? Because he took off. He got the hell out of Dodge, right? He got away as fast as he could. So there's no suspect to put in a photo lineup to show them. But we know that based on finding the car the next day and the rent-a-tire people, a suspect was developed. And so when Detective Duke and Detective Size went to Mike Flores' house and showed him the photo lineup the next day around 12:30 or so p.m. on that Monday, November 21st, he identified him. And defense counsel went on to talked a lot about this blind photo lineup process. There is no evidence before you that everything wasn't done properly regarding that photo lineup. And you know how you know that? You know it because Detective Duke testified and Mike Flores testified. Mike Flores is a stand-up man, right? He's not going to come in here and lie for the sake of lying. He told you that he saw it, and he told you, that's the man who did it. And he was certain. So you have eyewitness testimony to the capital murder of Detective Marconi. But that's not all you have, right? And you can look at someone's actions immediately, before, during, and after the offense. And you're able to look at their actions. And we talked about this in jury selection too. If someone gets rid of evidence or hides evidence, is that an indication of guilt? It is. And in this case, you saw that. First of all, the wheels, right? It's this unique car, right? And so at some point during the day, that Sunday, the picture of the car came out with the wheels. And so that's unique. Those rims really stick out. I mean, obviously, the rent-a-car people, they saw the rims. They're like, hey, that's the guy. It's Otis McKane. But the rims. So look at these pictures. All three rims. All three pictures. And it has the dates. These are clips from those SAPD videos, from headquarters videos, that show these unique rims. The rent-a-tire, right? We've connected that to this defendant. So not only did we bring you the testimony saying, I saw the picture of the man that entered police headquarters that morning when that was released to the media. All three of them. Michael Garcia, Justin Rodriguez, right? And Joseph Hinojosa. All three of them told you, as soon as they saw the picture in the car, and the pictures from that morning when the person entered police headquarters, all three of them said, that's the defendant. All three of them. And there was no uncertainty about it. You saw them testify. It wasn't like, oh, it looks like him, it could be him, maybe it's him. You saw him. It's him. All three of them. And how did they know? Because he came in every week to make his $113 payment on those rims. And they talked to him. They fixed a flat. They told you that he always wore Spurs hats. And what is coincidence? The guy who's entering police headquarters that morning. And they said is wearing a Spurs hat. And also a black hoodie. They talked about how he always wears a black hoodie. But they recognized him. And then we had the wheels pulled off, right? Because we're bringing you everything for you to see. To confirm that Mitsubishi Galant, that the serial number inside, the car that's registered to this defendant, matches the rent-a-tire records. So it gives credibility to what they're saying. If it didn't match, you'd say, well, is it really his car? Because the rims didn't match. Well, they do match. They match in appearance, but they match because they have the serial number of the rim inside. And here's a picture of it. So what does the defendant do? So we talk about what someone does before, during, and after. And we know the defendant takes off, right? We saw him in the video. And he buzzed through the first traffic arm on Santa Rosa. And when I watched this video, the first time I thought, well, I wonder, how does he know? When you watch that video, there's no hesitation how do I get out of this lot? Where's the exit, right? It seems like he knows exactly where to go. And maybe it's because he was there earlier, driving around, checking it out. Or maybe when he came later on that afternoon when he had driven around. Not afternoon, later on in the morning, 30 something, 11:28, whenever he's driving around before he pulls up behind Detective Marconi. But he knows exactly how to get out of this lot. And he buzzed through 18 and 19. Instead of going straight down Santa Rosa and taking a right on Cesar Chavez and then taking off, he cuts right through. And again, the significance of this, to show his guilt, is that the paint matches. Right? The paint matches the window, the front windshield and the back window on his car. And we brought you Christina Vachon, who did the scrapings. And she talked about how paint scrapings from windows are more accurate. It's pure because the paint from the top, the clear coat of the top, doesn't mix with the paint from the traffic arms to create kind of a mixture. But we brought you, she said, the front windshield and the back windshield of that car, she said it has the same physical. She said, we tried to exclude it. That's what we tried to do. We tried to say, oh, it's not a match, it's excluded. But she wasn't able to do it. She says those traffic arms have the same physical and chemical characteristics that's found on the defendant's car. It's that car. It's that car that busted through those traffic arms on his way to get out so he wouldn't get caught. And we know that's his car. Well, actually, you see the VIN number here at the bottom that was taken from CSI. You see the VIN number up top. It's his car. You also have the Texas Department of Public Safety records in here for you to look at. It's registered to Otis McKane and his mom, Sandy McKane. So what else do we know? He's a thinking man, right? He tells Detective Duke, I'm a thinking man. I'm thinking. And what's the first thing he does? Or pretty soon thereafter? He gets rid of the gun and his clothes, right? Can't catch me, I don't have the gun, I don't have the clothes, right? And how do we know it? Because he tells us. And here's his words.
What about your clothes? The clothes you were wearing? I threw those away too. I threw everything away. The same dumpster? Yeah. I knew that was one thing that y'all were there. It's hard thing y'all knew what happened. And then if y'all did, all y'all could do was change my clothes to what it done. I do it in a random location. Because whenever y'all found out, I knew that I had time for the garbage man to pick it up.
I threw it in a random location. Because whenever y'all found out, I knew that I had time for the garbage man to pick it up. Right? This is what's going through his mind. Getting rid of stuff, getting rid of the evidence. So he won't get caught. So he won't be held accountable for his actions. And what else do we know? We know based on the video, had there not have been that wreck that next morning, on Monday, November 21st, 2016, about 9:15 or so in the morning, and officers were called out to the wreck, had Officer Henderson and Officer Ortiz, they weren't needed at the wreck, and as they're driving slowly by, they look, and it's probably, I'm sure they did a double take, like, is that the car? And they see it, and they see where it's parked. And then Guillermo Gonzalez, who lives at that corner house with his mother at 1949 West Poplar, he comes out and tells the officers, I guess at the time of the wreck, hey, if y'all want to see video of the wreck, I can show you because I have a video camera. Well, that video camera just happened to have caught the defendant leaving the car there the next day. And you saw that video footage, and it's at 12:34, and you can see the rims, you can see the car. And so at first, when you remember watching, at first he's going to park facing the wrong way. And then it's almost as if he's like, oh, wait a minute. I don't want to be parked the wrong way. Let me move my car. So then he turns it and parks it correctly. And you can see at the upper left-hand corner of that screen, And that's the same place. And this is at 2:34 p.m. It's just shy of 3 hours after he unloaded 2 bullets into Detective Marconi's head. And he's ditching the car. And why is this significant? Right? Why is it significant? Well, it's significant because he's hiding the evidence. And we see him here. And you remember too, as he's walking by, he stops and he looks up at the street signs. It's almost to say, okay, now I got to remember where I'm parked. Like, where did I park? So he stops and he makes this kind of, and it's right here. I mean, for you to see. And you have the video too to take back there. But he looks at the street signs to confirm this car is parked. My car is parked at the corner of Calaveras and Poplar. He grabs his boots, his rubber boots, and he just walks towards LeBron, where he lives. And here's something that we need to ask, right? You need to ask yourself. Why didn't he park his car at 1236 Lombrano? You can see the red dot in the upper left corner where it says 1236 Lombrano. That's his home. Why does he, 3 hours after he kills Detective Marconi, he's ditching it. See on the right hand, kind of middle right of the screen, at that intersection, just shy of Poplar, but on Calaveras. He does it because he doesn't want to get caught. And then he doesn't stay at his house, right? We know that. He and Christian Fields, they go to the Econo Lodge, which is way out I-35 north, past 410. I mean, miles and miles from his house. I mean, he distanced himself from the scene of the capital murder. He distanced himself from the gun in his clothes. He distanced himself from his car, and now he's distancing himself from his house because if the cops figure out who it is, he won't be home. So we know they check in at 6:22 p.m. under the name of Christian Fields for 2 nights. You see them entering Econo Lodge at 1850, so 6:50 p.m. And what I think is real interesting about this picture and this video, and you'll have the video to see, is the shoes he's wearing. Take a look. Those are those same black shoes with the little silver emblem, the Air Force One emblem, that you'll have back there to look at, to compare. But he has those on when he enters police headquarters that morning. And he has them on at the Econo Lodge, here. And here he is again. They're upstairs. It's now same time 6:50. And that is clearly, we know from the evidence, that's Otis McKane. Not staying in his apartment. And there are the shoes. I mean, you can see them. These are the same shoes. And we find these shoes at his apartment. The police do. So there's some time between when he checks into the Econo Lodge, he then goes back to his apartment to put his shoes up. Because he has them that night when he checks in. But when they search his house in the evening, the shoes are here, right? On the Monday, November 21st. And here's a close-up of them. And think back at the Econo Lodge. He's there with Christian Fields and her baby. They're having, we know from this picture, they ordered pizza. And what's Detective Marconi doing right now? What's he doing? He's at the morgue. His body's at the morgue while this defendant and his wife-to-be, right, are living it up at a motel room, eating Pizza Hut pizza. And he gets married. He comes down here, this same building, where we've all been listening to his 2-week capital murder trial. He's down here, he and Christian Fields, wearing the same shirt from the Econo Lodge. But at 9:54 a.m., they're here. They're getting married. The day after he kills Detective Marconi, he and Christian Fields get married. And now they're leaving at 10:28. He's not wearing those shoes, right? So I don't know where, I mean, maybe he went to his apartment beforehand or he went afterwards, but... And we know, the reason why I think this picture is significant, remember Detective Danny Martinez testified, and he talked to you, you heard all about the covert surveillance that was going on. And again, about the defendant's actions. He's watching Lombrano in case they return back. And Christian Fields, sometime late, and he doesn't know the exact time, but in the afternoon on Monday the 21st, he sees the white Buick come up and park. And she gets out, and the passenger seat is reclined. And he doesn't know who's in it. He can see it's someone, but he can't identify the person. Okay? Why? Why is the defendant reclining that seat? Why doesn't he want to be seen? We know. He doesn't want to get caught. And we know he's in the passenger seat because when they're stopped, this video shows that he's getting out when he stops at the Church's Chicken gas station. He's getting out of the passenger seat. And Christian Fields, when he goes inside and comes back, and then Christian Fields gets out of the driver's seat, and then he gets into the driver's seat. So when he's arrested, he's in the driver's seat. And when they search her car, they find the keys to the Mitsubishi that we've seen that was at the scene that morning, later on at 11:38, the same car he ditches, and he has the keys to that car. So it's important, too, when you think about, the defense is trying to say that his statement was not freely and voluntarily given, right? Without compulsion or persuasion, right? They're saying it was. You saw that statement. You had it with you. Detective Duke was nothing but professional with the defendant. He offered him, the defendant was allowed to use the restroom. He offered him water. He brought him a straw. He even helped him drink it. He never yelled at him. He was extremely professional with this defendant. His rights were read to him very slowly. He was asked if he understood his rights. He was also asked by Detective McKay if he understood his rights. And both times, the defendant said, both to Detective Duke and Detective McKay, the defendant said yes, he understood. And the law does not require, okay? The law does not require a police officer to say, do you knowingly, intelligently, and voluntarily waive those rights? The law requires them to read them the rights and ask if they understood. The defendant said yes, and he began talking. And he engaged in the interview. And based on what the defense attorney said, it seems like he wants you to make up new law. It's your time to make up some new law, right? Where he said to you, he says, sometimes the law just isn't right. Let's come up with our own law, where you are bound by the law that this judge gives you. And he admitted, the defense attorney and Detective Duke, that he did not violate a single law when he took the defendant's confession. He was allowed to use certain interview tactics, but they are allowed under the law. And if they weren't allowed, if he did anything improper, you would not have seen his confession. You would not have seen it. So it didn't happen. Everything was done correctly and under the law. And here's something else too. So if you look at this statement, this video when the defendant's leaving, this is not a product of law enforcement. This is a defendant being escorted out, and the media is asking him questions. And he's answering their questions. So even if one of you or two of you decide, well, I don't think he freely and voluntarily gave his statement. I think it was there was some compulsion or some persuasion used, and it was unreasonable. Then there's other evidence. Clearly, there's eyewitness testimony. There are these admissions when the media is asking him that are not a product of law enforcement questioning or custodial interrogation. And so here's what he tells the media when they're asking him.
Anything you want to say? Being accused without killing him.
I just want to see my son.
For what?
I just want to see my son. It's society not letting me see my son. I got to tell somebody to read the good.
Did you do it?
No, sure.
What you doing? What was his fault? You want to see his son?
I've been through several custody battles, and I was upset. It's a situation I was in, and I got to tell somebody to read the good.
Everything he said was family?
I was already saying it also. I didn't mean for it.
That's the way I'm saying. He's going to just take over something.
Yes, sir. But still, I see my son.
It could have been anybody. Did you hear him say that? It could have been anybody. And then he uses the excuse, I just want to see my son. And at the very end, it's back to him. Everything is back to Otis McKane, right? It's back to Otis McKane. Oh, I still didn't get to see my son. I still haven't seen him. And what do we know? We know from Detective Duke, his testimony, and Kevin Wilkinson, that he hadn't filed a report in over 2 years. And Detective Duke found 2 or 3 reports all together that the defendant filed. But that day, he comes and he blows away a detective sitting in his patrol car because he just wants to see his son. So Officer Chris Enfinger, he's the one who, he and Detective Mascoro, who you just saw on that video, the media video, they're the ones that drove the defendant from the scene of arrest from IH-10 1560 to police headquarters. And the defendant tells you in his own words that they didn't say nothing. He said, they asked me my name. That's the only thing that they said. The only communication was that they asked me my name. So he's not saying that they threatened him, they coerced him, anything, but they injured him. He tells them, he tells Duke he wasn't even injured. So Chris Enfinger's there. He's glad, he said he's glad he shot him. You can't judge me. It felt good to do what he did. Had to do something to get someone to listen. Well, these statements are consistent with what the defendant told Detective Duke. And he wrote it right away in his report. His report, he told you, he went back to the station and he wrote it right away. And Parker Morris, it felt good to shoot him. Again, consistent with this defendant, with the statement he's telling Detective Duke. So you think they made it up? These guys don't even know each other. Parker Morris works at the detention center. Officer Enfinger's a SWAT officer. I mean, they're not buddies. They don't know each other. And they independently heard him say that. And Parker Morris, he's not even, I think he's, 18 at the time? He didn't even know what to do. So he runs and tells his supervisor what he heard. And the supervisor says, document that in that report. And he does it. Right immediately, he writes, quote, it felt good to shoot him, coming from this defendant. And Elroy Brown, again, another statement that's not a product of custodial interrogation. He ends up going from the detention center, the defendant goes to the Bexar County Jail. And so it's a mental health screening. That's a regular process that takes place. And you heard Elroy Brown say the defendant admitted to him to shooting a San Antonio police officer. It wasn't about the man he shot, but was about the uniform. Elroy Brown has no idea what this defendant had told Detective Duke, right? He has no idea. He wasn't part at the police station. He didn't have an opportunity to watch that video. How is he getting this information? Because the defendant told him that. And we know it's true because that's what he told Detective Duke. So, think about Elroy Brown's testimony. The defendant was trying to make a statement with the uniform. All of these statements that he made point to his guilt. It's an admission of guilt. And the most detailed information he gives, which is also the most damning, is his confession to Detective Duke. And take a look. These are his statements coming from his mouth.
I took it on the first person I seen because I didn't think to see that before. You know what the fuck somebody like that. And what it could have been a 21-year-old.
And before that, you know, we watched, what, an hour or so, it seemed like, where he denied. He lied and lied and lied. I wasn't there. It wasn't me. Y'all are trying to get me for the shooting. And Detective Duke says, "What shooting?" He's like, "Oh, shoot, nothing." And then he tells Detective Duke, too, "People are blowing up my phone. People are saying, 'Hey, that looks like you, my family.'" They're all calling. Detective Duke said, "Who?" And he's like, "Nobody." Right? So he's kind of playing Detective Duke, too, as you can watch in the video. He is playing him, trying to find out how much information do you have before I'm going to let you know what really happened. And he finally decides to come clean with Detective Duke when he finds out that he can't talk his way out of it.
You know, I just want to let everybody know that I tried to do everything I could before I sent it to the
And what do we know, too, from this video? You know, they brought up a lot of... Mr. Pettis talked to you about, well, we don't know if he had smoked a joint, if he had drank beer, or what. We know from Detective Duke, who's been a police officer now almost 26 years, but then, 21 years or so, that the defendant did not appear impaired. He did not smell anything, any alcohol. He didn't smell marijuana under the influence of anything. And the defendant told him that he had graduated from high school and had gone to 2 colleges.
I wanted to make the police station feel the burning I felt in my heart, sir.
I wanted to make the police station feel the burn that I felt in my heart, sir. His words.
And I thought the only way of paying back this world before I lived it hurt somebody. There was no justice in what I did.
Well, we couldn't agree more with that statement, right?
The thought of me beating somebody up or shooting somebody, the only thing is shooting myself at that moment. But, I ain't dead. I knew from the moment that I pulled that trigger that wasn't the right thing to do.
And how dare he blame that he didn't get to see his son or hadn't got to see his son on his actions? How dare he?
But my emotions got over me. I took it out in the first place. And sir, man, I wanted to cry and apologize to this person but something in my heart just won't let me, man. I don't care about nothing, man, because I don't have nothing to live for. The only thing I want to do is hurt somebody because I know my life ain't nothing, sir.
Do you still feel that way?
Yeah, I still do, man. And 31 years of my life made me go up to that police officer and do that. I said it twice.
And we know from watching that Inside Covan video that this man ran up to Detective Marconi as he's sitting inside the patrol car. He fired one shot right by his left nostril and his cheek. And you heard from Dr. Roulan. You heard how close that was. And we know from the evidence that he never saw it coming. Detective Marconi did. You see the powder tattooing on his face from the burns from the muzzle of the gun. And you see it in his left eye. You saw that picture. He was sitting in the patrol car, running Ricky's information, Ricky Martinez's information, when this man came up from behind him, ran up from behind him, and shot him right here. And it comes out underneath his right ear. But he didn't stop there, right? He didn't stop there. He's not done. Detective Marconi grabs his cheek and kind of goes down, and you can see that in the video, kind of the tips of his fingers. And he goes down, and he just close contact wound to the back of his head and pulls the trigger again. And that bullet enters the back of his head, and you can see in this picture where it comes out. It went right through his brain, fractured his skull in multiple places. And the guy takes off running, right? And we already went through all the stuff that he did that day and the next day, goes to a motel, eats pizza, ditches his car, gets rid of the gun, the clothes, gets married, right? But what's Detective Marconi do? Well, we know he then goes over to the passenger seat after he's shot, and he's waiting. It's like, is he waiting for someone to come out? And Officer Zygmunt is walking out and sees the defendant pass by quickly. He's not sure what just happened because he comes out after the fact and looks over at Ricky, and Ricky's doing this like, hey, wasn't me, Ricky's concerned. But he runs over there, and he and Mark Bissett carefully take Detective Marconi from inside the police car, and they lay him down. And Frank Ruiz, who's a member of the SWAT who you heard from early on, they're applying pressure to his head because he's bleeding profusely. Detective Marconi's mouth keeps filling up with blood. He's choking on his blood because he was shot through his tongue, and so he can't, the tongue is bleeding, his mouth. And EMS gets there right away, within minutes. They place him on the car, on the board. He's rushed to SAMC, a trauma center. And they did everything they could do to save his life. You heard and you saw Dr. Erica Simon. I mean, when does an ER doctor who's in a trauma, an ER doctor in a trauma room break down like that? And she told you, I'm standing at the edge of the bed, and I'm calling out orders, and she says, we're doing everything. CPR is being done constantly, and we're checking for vital signs, and there's no vital signs. And so we keep, we're suctioning the blood. We had to use 4 units of platelets and 4 units of red blood cells to attempt to save his life. And at one point she looks down and she feels like this warmth in her feet because she's standing in Detective Marconi's blood that's pouring from the back of his head down the mattress that he's on, the pad that he's on. Underneath that, see the blue sheet, and it's just pouring down. And at 12:22 p.m., she calls his death. And this is Detective Marconi. And this is because of this man's actions. It's not about his son. He targeted Detective Marconi because of his police uniform he was wearing. Because he was a police officer. He didn't know him. He didn't have any, it wasn't an issue like Detective Marconi was trying to arrest him or they had any kind of conflict. He didn't know him. It was the fact that he was sitting in a patrol car. The lights were on. He was wearing his uniform. And he shot him execution style twice. And that's why we're here. We are here because of his actions and what he chose to do. This was an intentional and knowing act. He took this man's life away. Detective Marconi did nothing wrong. He was doing his job. But he decided he was going to end his life. He decided by putting the gun and shooting him first in the cheek and making sure that it was over. For Detective Marconi, let me get one more shot in. And he shot him in the back of the head. 20 years of service with the San Antonio Police Department ended like that because of his choices, because of his actions. This defendant is guilty of the capital murder of Detective Benjamin Marconi, and we ask you to find him guilty because it's the only verdict possible based on all the evidence you've heard. Thank you.
All right, members of the jury, you now have all the evidence before you. You have the law through the charge of the court and closing arguments of counsel. Once all of you are assembled in the jury room, you may begin your deliberations. We'll be in recess until you've advised us that you've reached a verdict.
All rise for the jury.